matter of the Crown on the application of PACCAR and others against the Competition Appeal Tribunal and others.
Lord Sales will hand down this judgment.
This appeal is concerned with the proper interpretation of a definition set out in the statute. The dispute about the meaning of the statutory definition arises in the context of litigation funding. Litigation funding involves the agreement of a funder to finance the costs of litigation in return for a percentage of any damages recovered if the litigant is successful. Litigation funding can be an important way for people to be able to gain access to justice in circumstances where they do not have the means or a sufficient incentive to pay for litigation by themselves. That can be especially important in cases involving breaches of competition law, where there may be a lot of people who have suffered from an unlawful increase in the prices they have paid for goods, but an increase so small in each individual case that it would not be economic for any one person to bring proceedings to vindicate their rights. In that situation, it may be necessary for a litigation funding agreement to be made whereby a funder agrees to pay the legal costs for litigation on behalf of the whole group, in return for the group agreeing that the funder can take a percentage of the overall damages recovered if the claim is successful. Such claims are brought before a specialist tribunal called the Competition Appeal Tribunal. That is the context in which the present case has arisen. It has been established in European competition proceedings that the truckmaker DAF and other truckmakers operated as a cartel to charge increased prices to their customers in breach of competition law. The litigation funders, who are the respondents in this appeal, have come forward with a proposal to fund claims by the customers in the tribunal to recover damages in respect of the increased charges. But in order to be allowed to proceed with these group claims, the funders need the permission of the tribunal, and in order to obtain that permission, they have to be able to show that they have got valid and binding litigation funding agreements in place to cover the cost of the litigation, including if the customers lose. That is where the point of statutory interpretation comes into play. There is a statutory regime in place which requires certain funding agreements, which are called damages-based agreements, or DBAs for short, to comply with certain formalities for the protection of the litigants who sign up to them. There is a statutory definition of a DBA. Section 58AA of the Courts and Legal Services Act 1990, which came into effect in 2013, provides that litigation funding agreements which fall within the definition of a DBA, where the formalities have not been complied with, shall be unenforceable. If the litigation funding agreements in this case fall within the definition of a damages-based agreement, or DBA, Section 58AA means that they are unenforceable. If they are unenforceable, there would be no effective funding in place for the collective proceedings in the tribunal, and the tribunal could not give permission for those proceedings to go forward. Therefore, the question whether the litigation funding agreements fall within the statutory definition of a DBA is critical. DAF says that the litigation funding agreements do fall within that statutory definition, with the result that they are unenforceable. The funders say that they do not fall within that definition, with the result that they are valid and enforceable agreements. If DAF is right, the collective claims cannot proceed in their current form. If the funders are right, those claims can proceed. The material part of the definition of a DBA under Section 58AA is whether the funding agreements involve the provision of, I quote, claims management services, end quote. That phrase is defined by reference to the definition given in earlier legislation, the Compensation Act 2006. So the critical question in the present case depends upon the definition of DBA in the 2006 Act. The 2006 Act refers to regulated claims management services. Such a service is regulated if it is stated to be regulated in an order made by the Secretary of State. Such a service is defined to be advice or other services in relation to the making of a claim, and other services includes, in particular, a reference to the provision of financial services or assistance. DAF, the appellant, says that the funding agreements involve the provision of financial services or assistance, and so are caught by the definition. The funders say that the whole definition has to be read as applicable only in relation to something which can be said to involve the management of a claim. Since they only provide funding and are not involved in active management of the claims, the funding agreements do not fall within the definition of a DBA and therefore they are enforceable. The tribunal held that the funders were correct. On appeal, the Divisional Court agreed with the tribunal, so DAF has appealed to the Supreme Court. This court allows DAF's appeal by a majority of 4-1. I give the main judgment with which Lord Reid, Lord Leggett and Lord Stevens agree. Lady Rose gives a dissenting judgment agreeing with the Divisional Court. An important feature of the case is that the definition of a DBA derived from one legislative context, the 2006 Act, has been used in the different legislative context of Section 58AA. The meaning of the definition has not changed, so the meaning has to be determined with reference to the 2006 Act. Having regard to the purpose and regulatory scheme of that Act, it makes sense to read the statutory definition of a DBA in line with the submission advanced by the appellants. The funding agreements clearly constitute the provision of financial services or assistance, so they fall within the definition according to the natural and ordinary meaning of the words used in that definition. Moreover, the purpose of the 2006 Act was to provide a broad power to allow the Secretary of State to decide what targeted regulatory response might be required from time to time as information emerged about what was then a new and developing field of services seeking to encourage or facilitate litigation, where the business structures were opaque and poorly understood. The definition has to be read in a way which gives effect to that purpose, and this strongly supports giving the words used in the definition their wide and natural meaning. That is how Parliament intended the definition to be interpreted. In addition to this, the order made by the Secretary of State to identify the services to be regulated pursuant to the 2006 Act is an aid to interpretation of that Act. It too supports the submission of the appellants that the words of the definition should be given their natural meaning so that the funding agreements fall within it. By contrast, the arguments of the funders lack force. In particular, their contention that the definition has to be read narrowly as confined to services which can be described as involving management of claims cannot be reconciled with the various specific activities expressly identified in the statutory definition and in the order made by the Secretary of State. There is no common thread of management of a claim which unites those activities. On the contrary, they are activities which do not typically involve management of a claim. So this provides no good ground for departing from the natural meaning of the words of the definition chosen by Parliament. To do so would render the definition vague and circular rather than clear and precise as Parliament intended it to be. It would also defeat the wide regulatory purpose of the 2006 Act. For these reasons, DAF's appeal is allowed. The funding agreements fall within the definition of damages-based agreement and are therefore made unenforceable by Section 58AA of the 1990 Act.
The court will now adjourn.